My name is Paula Price. I'm with the People's Law School, and we're here today with our webinar, Settling in the State in British Columbia, Probate from Three Perspectives. And I'll be introducing our speakers in a moment: Laura Hill, Nicole Ayukawa, and Nicole Garton and Stacey Ayukawa. And we are really, really excited to have everyone here today with us. Before we jump into the substance, we'd love to get a feel for who we have in the room with us today. So we're going to run a quick poll. The options are: I'm settling in a state on my own, I'm settling in a state working with a lawyer, I assist people with legal problems, I'm a legal professional, none of the above, but I'm interested in the topic. And while we run that poll, I just wanted to let you know we are recording today's webinar. Post a link to the video recording on our website, along with links to the resources that we're going to be sharing with you today. Also, as we go through the webinar, you'll see hyperlinks being dropped into the chat and into the Q&A, and we'll be giving you an opportunity at the end of the webinar. We'll stay on the line for about 2 to 5 minutes so that you can scoop out or copy and paste any of the links or the comments that you'd like to keep. In addition, if you've got ideas for future webinars, we'll be running a survey at the end of the webinar, and we'd love your feedback because we base the substance of our programming and the way we deliver on feedback from you. So the time you spend on that is very valuable to us. So we've got our results. It looks like we've got a number of people who are interested in the topic who aren't currently involved in the states, and that's fabulous. We're really delighted to have you here learning about the process. We've got a number of people who are in the process of settling in the state. That's great. We've got assisting people with legal problems. Again, we're delighted to have you all here. And we know we have a lot of public librarians, and we have librarians over at the Courthouse Library who share with us that they receive a lot of questions. And so we hope this webinar will become a resource for them as they go forward. So this webinar is for members of the public who are settling in a state, those who are helping individuals settle estates, people who are interested in the topic. It is not for in the dark beneficiaries or individuals who have questions about estate planning. And we just wanted to clarify that because these are topics that we also receive a number of questions about, and we hope maybe to do webinars on those topics in the future, but really today's topic is about the settling of an estate process. In terms of what you can expect today, we have a 60-minute webinar planned for you. And what we've done is Nicole and Stacey and their team have collected some of the most common questions they receive. Laura has also done the same, and we over at Peoples have collected the questions that we receive most commonly. And so today's presentation is based on the most common questions that we have seen. What we'll be providing is legal information, not legal advice. So if what you're seeking is the law as it applies to your particular set of circumstances, we'd encourage you to seek legal advice. And if you would like to contact Nicole and her team, the email address is here, info@bcheritage.law.com. And the information we're providing is current as of today. So today we're June 3rd, 2020. We'd love to hear from you as the webinar unfolds. There are 2 buttons that are on your toolbar that may be of interest. One is the Q&A function. So substantive questions go into the Q&A function. You can make your question anonymous if you like. You can keep your window open as you watch the webinar, and if you see a question that you like, you can hit the thumbs up button, and that will promote that question to the top of the list. And we're going to try to reserve about 10 minutes at the end of the presentation to answer questions. And if past webinars are any indication, we tend to receive a lot of really great questions from our audience members, but we typically don't have time to get to all of them. So we'll answer the ones that have the most likes first. So if you see something you like, please promote it. The other function that will potentially be useful to you is the chat function, and so you can make your comments in the chat function. That's really if you have a question about tech or just a general comment. If you are watching from Facebook Live, we're also streaming to Facebook Live. You'll have the opportunity to make comments in the comment fields, but your questions will not be transmitted through to Zoom. If you would like to try to do that, you're always welcome to log in through the webinar channel. That's the only way we'd really be able to hear your questions. Just that final note, we're going to be dropping a number of links into both the chat and Q&A. And so we will hold the line open for about 5 minutes after the webinar so that you have time to collect that information. And before we introduce our speakers, we're now just moments away. We'd like to extend a thanks to everyone who has made this possible. I'd like to begin by acknowledging that the land on which our Peoples team is located is the unceded territory of the Coast Salish peoples, and that is including the Musqueam First Nation, the Squamish Nation, and the Tsleil-Waututh Nations. And we would also like to extend that acknowledgement across the province. We have our guests who are logging in. We've got participants we saw there logging in from all over BC. So we just extend that throughout. We'd also like to thank the Law Foundation of British Columbia. The Law Foundation is People's Law School's primary funder, and it's thanks to them that we can put on this type of production. It is also helps us fund all the information that is on our website, which we will be providing links to throughout the webinar. We'd like to thank everybody for the opportunity to be here. We're really excited to have this opportunity to connect with everybody who's attending today. So thank you for being here. And of course, we have our speakers. We have Nicole Garten and Stacey Ayukawa from Heritage Law, and we've got Laura Hill, who's joining us from the Vancouver Law Courts. So starting with Nicole, Nicole is a lawyer. She's the founder of Heritage Law. She's also a mediator, and Nicole's practice includes a focus on estate planning, estate administration, and assisting parties resolving their estate disputes. So welcome, Nicole. Thank you so much for being here today.
Great. Thank you very much for asking us.
We've also got Stacey Ayukawa joining us. Stacey is a paralegal with Heritage Law. She's also an instructor at Capilano University, and she teaches wills and estates courses. And when we reached out to Nicole, she highly recommended that we bring Stacey on board. She said, the minute I started talking about forms, she said, Stacey knows these inside and out. So we're really delighted to have Stacey join us today. So thank you, Stacey.
Thank you for having me.
And last but not least, we have Laura Hill. Laura Hill is the supervisor at the Probate and Bankruptcy Department at the Vancouver Law Courts, which is the highest volume probate and bankruptcy department in the province. She's also a deputy district registrar and a justice of the peace. And as deputy district registrar, Laura has authority to grant a number of significant orders, including the grant application. So thank you so much, Laura. It's really great to have you here today.
Thank you for having me.
It's wonderful. And so with our dream team here, we're going to turn to the frequently asked questions. And the first one is for you, Nicole. And it's sort of a general question, but what is probate?
So probate is a legal procedure that confirms that a will is legally valid. So it is part of the larger process of what is called estate administration, which is basically managing the estate of someone who's passed away.
Excellent. And Nicole, when we speak about probate, is it something that everything needs to, do all assets need to go through probate?
So the answer is no. So, for lay people, probate is effectively a confirmation from the court that a will is valid. And it, in practice, is a stamp on a document that confirms that a court has found that the will is valid. You only need to go through that court process in certain scenarios. So one of them is if somebody passed away owning real estate in their own name, the Land Title Office of British Columbia requires probate to convey title in real estate. Also, most of the financial institutions have about a $30,000 threshold. So if someone passes away and they have about $30,000 or more in investments or cash or similar, generally speaking, most of the banks will require that that confirmation that the will is legally valid to transfer those assets. So if somebody passes away and they own things jointly, so for example, say a husband and wife own their family home jointly, if one of them passes away, you don't need probate. You would just file the death certificate in the land title office. The document's called a Form 17, and that removes the deceased person from title, and you do not require that stamped will for that. So really, if they have joint bank accounts or they're each other's designated beneficiaries of RSPs, pensions, life insurance, that kind of thing, none of that requires probate to deal with those assets.
Okay, thank you, Nicole. So it sounds like there's really a number of factors to consider when deciding whether or not to go ahead with the application. Now, in the process, we hear the word probating, we hear the word administering an estate. What is the difference between the two?
So thank you for asking that. And a lot of people find that really confusing. So as we alluded to earlier, probate is that legal procedure that confirms a will is valid, and it's literally the stamp from the court on the will. Administration is the larger process. So if somebody passes away and you are appointed executor under a will or administrator by the court, you have a responsibility, a larger, what we call fiduciary responsibility, to manage the estate, comply with the terms of the will or the distribution in the Wills, Estates, and Succession Act, notify beneficiaries, make sure creditors are paid, make sure all the tax returns are filed, and that all the assets are distributed to the correct recipients. So in short, administration is the larger responsibility in an estate, and probate is more of the distinct process of getting that sort of confirmation that the will is in fact valid. And as I mentioned, sometimes people come in and they're not sure if they need it or not. Generally speaking, it's when somebody passes away owning real estate in their own name, and or if they have about $30,000 or more in their own name, that's generally when you need probate. So if people are married in a first marriage, generally speaking, you don't need probate until the second of them pass away, if that helps.
Oh, it's so interesting. So really, I mean, the probating is one piece of the administering, and I imagine then in most cases you'll require the administering piece of it, the figuring out what happens with the assets, but the probate is only in the circumstances that you described.
Correct.
It leads to another question, again, sort of clarifying terminology that we hear, which is the difference between an executor and an administrator.
So an executor is the person who is appointed under a will, and sometimes that person doesn't want to act, or maybe that person is incapable or they've passed away, and so then there's not an alternate. So then you need an administrator, and so that's called letters of administration with will annexed. Another time you need an administrator is if somebody dies intestate, which means they die without a will, which is a lot of people, by the way. Approximately half of Canadians have no will. That's a lot of people. So when somebody dies without a will, then somebody needs to be appointed administrator, and so you do need to go through that court process to appoint somebody who has the requisite authority. And there is a legal difference. So if somebody passes away and they have a valid will that appoints an executor who's able and willing to act, that person's responsibility starts the moment that person passes away, immediately. If you're going to be appointed administrator by the court, that responsibility doesn't start until the court appoints you.
That is so interesting. So I suppose that means that if you've got the executor named in the will, that their duties become effective as of the moment of death. Is that
correct? Yes.
Interesting. And Nicole, what are the duties if you are an executor and appointed under the will?
So it's a very serious and quite frankly, thankless task to be an executor. It's a very, very serious responsibility, which I mentioned, which is called the fiduciary responsibility. So in layman's terms, you have to do a good job, and you always have to act in the best interests of the beneficiaries. And, you know, there are very serious requirements, and there's a lot of minefields. So if you're considering taking this role, it's important that you get really good advice and that you assess the risks and responsibilities in the estate to make sure that you're willing to take this job on. Because if you make a serious mistake or you don't manage it, you are subject to quite serious liability for potential damages and loss.
Okay, thank you, Nicole. And let's say that there is a question about the will. Who is entitled to challenge a will?
So there's 4 ways to challenge a will. The first way is you can say that the will wasn't executed in accordance with the Wills, Estates, and Succession Act, which is, I believe, Section 30 of WISA. So that would mean that it wasn't witnessed or signed correctly. That said, though, there's a saving provision we have now. So the Wills, Estates, and Succession Act was brought in 2014, and there's a new section in there called Section 58 where we can rectify errors. But to go back, number 1, you can say the will wasn't signed correctly. Number 2, you can say that the testator, and that's the person that did the will, you can say that they were incapable. So they didn't have the requisite legal capacity to enter into the will. A third way to challenge a will is you can say that there was something called undue influence. So that would be if somebody was in a position of dominance or control over the testator, if they exerted their will to compel the testator to do something different than what they otherwise would have done. And then the final way is if you are a spouse or a legal child, even if you're an adult independent child, you can say it's unfair, and that is under Section 60 of the Wills and Estates Succession Act. So you can say that the will didn't make adequate provision for you. So those are the 4, I guess, the hit list of the way you can go after a will. But I just want to back up and say the way to avoid these issues is to get really good advice and spend the time to get advice and do a good will, so your family isn't left with the stress and expense of dealing with a potential issue like this.
Absolutely. And just a quick question, Nicole, the individuals who would have the standing or the ability to challenge the will, would they all be receiving notice of the probate application when it goes ahead?
Correct. So we have to give a notice. It's called the form in the Supreme Court forms is called a P1. And Section 121 of WISA sets out who we're supposed to notify. So it's the named living executors, I'm just reading right from the Act, with equal or prior right to act, all the beneficiaries in the will, anyone entitled under an intestacy. So if somebody died without a will, anyone who would be would receive it under the Act. If there's no will, you have to notify all creditors who have a claim over $10,000. If the person who died is a Nisga'a citizen, you have to notify the Nisga'a government or Treaty First Nation. Anyone ordered by the court or someone who has served a citation. And you have to notify the public guardian and trustee if there's minors or people that aren't capable of beneficiaries. And if somebody has a committee, so if any one of those people has a legal guardian acting for them, you have to notify the committee as well.
Okay, thank you. Thank you, Nicole. You alluded to this a minute ago, but in the event that there's no will, what happens? Who basically takes charge in that situation?
So that is often quite a stressful and difficult situation that many families go through. And we get a lot of calls actually from panicked family members. If somebody has passed away unexpectedly, like who has authority? I actually have this written down. So, so under section 130 of WISA, basically the court can appoint what's called an administrator to take charge. And there's sort of an order of the expected people who would apply. So if someone had a spouse, and then after that a child of the person who passed away, with consent of a majority of the deceased children, the children of the deceased without majority consent, any other intestate successor, so anyone else entitled to benefit under the legislation. After that, intestate successors without consent, and any other person the court considers appropriate to appoint. So if nobody steps forward, often the public guardian and trustee will step in and administer the estate.
Okay, and what happens to the estate? I mean, do the assets flow to the government? What happens to them?
So that's when, that's pretty rare. So that's called escheating to the crown. And I've actually been a lawyer for 20 years, so I luckily haven't seen that yet. So it's pretty uncommon. So if somebody dies without a will, you actually do have a will. You have a legislated will. So the Wills, Estates, and Succession Act sets out who gets the funds. So if there is so if you pass away and you have a spouse but no children, then the spouse gets everything. If you have a spouse and children, if your children are mutual, the spouse gets the first 300,000, and then the children get the balance. If the children are not mutual, so say you had a blended family and your spouse, and there was children that were not the children of your spouse, the spouse gets the first 150,000, and then the balance is shared. The spouse gets the household furnishings and the right to purchase the spousal home. And so the residue, I don't know if I've been clear. So the balance goes half to the spouse and half to the children. And then if there's no spouse and no children, and then if there's no spouse and children, it goes equally to the children. And by the way, children are natural born children or legally adopted children. It doesn't include stepchildren that are not legally adopted. So if there's no spouse and no children, then it goes to the parents of the surviving parent. And then if none of those, then descendants of the parents. Then if none of those, half to each set of grandparents or their descendants, and on and on and on.
Yeah. And I gather, Nicole, this is all, you mentioned this is a legislated will. So the rules of succession in the absence of a will are all set out then. Is it in the WESA, the Wills, Estates and Succession
Correct.
Act? Or?
It's set out in the Wills, Estates, and Succession Act, and it's called the Paleontelic. Is that the right way to say it, Stacey? It's
Parentelic.
Parentelic.
Yes. And my initial word for describing probate was mysterious, and I think that would fall squarely in, at least for me, into that category. It's very much a web of figuring out who is entitled to what.
There's one more important thing I want to say. As prior to 2014, if people, so say if a couple passed away like in an accident and they didn't have a will, if the person who was younger was deemed to have died second, and the entirety of the estate was deemed to have been inherited by them and then by their descendants. Now, if a couple dies and there's no will, any jointure they have is now severed. So say they owned their home as joint tenants, which many married people do, which means if one of them passed away, the survivor receives it. I don't want to get too technical, but the other way is tenants in common, which is one of them died, their share goes into their estate. So if they own it jointly or any other assets jointly, under WISA since 2014, it's deemed to have severed the tenancy at the moment that they pass away. So the idea is that the estate will be distributed more equally between the branches of the family, whereas before, very large sums of money went to relatively small numbers of people.
Okay, interesting. Nicole, we touched on this a moment ago, I believe, the who gets notice when there's an application for an estate grant. If you are the executor and you are also the sole beneficiary of an estate, do you still need to go through the notice requirements?
We actually just did this on a file, and yes, he gave notice to himself just to
There you go.
Tick the box,
To
Tina.
dot the I's, cross the T's. And would you wait then that full 21 days or?
You know, I mean, the registry can speak to this, but I think it's easier just to comply with the rules and things are smoother generally rather than not.
Fabulous. And what about the situation where you can't find the person who's entitled to notice?
So that actually doesn't happen that often. Stacey, can you refresh my memory? When was the last time we even did this?
Usually we try to hire a skip tracer. And if that doesn't work, then you would probably need to obtain an order from the court dispensing with notice to that beneficiary. And you'd have to set out all of the attempts that you made to try to locate that beneficiary.
Right. Okay.
Yeah.
Nicole, I have one last question for you, which is, for individuals out there that are thinking about doing this process on their own, can they do that, or do you need to have a lawyer to go through the probate application process?
So you can absolutely do this on your own. So all the forms are available online. There's a lot of public information online. So if you're an organized person and you're conscientious and you're good at filling out forms and you're sort of a patient person, you absolutely could do this on your own. You don't need a lawyer to do a probate application. But I would say if it's a higher risk estate, so if there's a question about the validity of the will, or potentially, like if, those 4 grounds to challenge a will, if any one of those challenges is happening, I think it would be prudent to retain counsel. Or if you had, a disabled beneficiary, there's reasons. If in an estate that's very straightforward and there's no obvious immediate issues, you could do this yourself. But if there's more complexity and or there's open issues about the validity of the will, or there's beneficiaries that may be unhappy, then the idea to get advice. And just remember that being an executor is full of risk and potential liability, and so it's important to get advice at the outset. And if you obtain proper legal advice, that is a reasonable expense of the estate. And so it just makes sense to get advice where you need it.
Excellent. Thank you so much, Nicole. I have sort of a next branch of questions, or we have a next branch of questions, and these are really for Laura in terms of what happens over at the Probate Registry. And I just wanted to sort of make an introductory comment. When I reached out to Laura, I went to the law courts and we had a really interesting conversation, and she mentioned to me something that I never really thought about, which is that for most individuals who are going through the probate process, this is probably the first and possibly the only time that they will ever really interact with the court systems. And those people come at a time when they've had a loss, often a family member, and that the probate process is really one of the things that stands between them and closure in respect of an individual's death. And it was really striking to me in speaking with her just to hear about how she and her team at the registry are looking to. It's almost they're looking to support individuals who are going through this process. So I just wanted to mention that because it is a bit of a mysterious process even for lawyers that aren't in this practice area. So that really, I thought, kind of helped make the process seem a little bit less intimidating. So Laura, I would ask you the first question, which is kind of a general question. What happens at the Probate Registry?
Well, thank you for the lovely introduction, Paula. What happens at the registry? I would say the probate registry has 2 main roles. The first is an administrative one. The staff will file the will, the original will, all the forms related to the application, and any other court documents to open your probate court file. They take payment for your filing fees. It costs $200 to open a probate file unless the estate is less than $25,000. So they'll take your money. Ultimately, they'll take your probate fees at the end of the process. Registry staff can also swear affidavits. They can field general inquiries from the public by either phone or counter service. And they set court hearings and process court orders. So that's the administrative side. And then the second role that my program plays is an adjudicative one, where our registrars will review and issue representation grants in uncontested applications. So there can be no notice of dispute filed, there can be no contest. It has to be an unopposed application, in which case our staff have authority to consider the application and ultimately, hopefully, issue you the grant.
That is really interesting. I didn't realize that you were able to help swear affidavits. That could be very helpful for individuals who are doing their own materials and need somebody to do that for them.
Yeah, it costs $40.
Is that right?
So,
Yeah.
you know,
That's, and I know a lot of people are always wanting to know how much time something takes. So how long does it normally take for the application process to complete?
well, it's never an easy question because it does totally vary. It varies based on the capacity of the registry, and it varies on the complexity of the application and how many times we would potentially need to reject it, get more information, wait for the applicant to provide us with that information. Sometimes orders are required with issues like deficiencies in the will, like Nicole mentioned. If it hasn't been properly signed or witnessed, those things need to be remedied. So it really depends. And I can only speak for the Vancouver registry. We're really unique. We've got the most staff out of any probate registry in the province. So sometimes we can be faster. For us, it's about, I would say on average, 3 to 8 weeks. You can expect to have your application checked after the time it's been filed. But how long it takes between when it's checked and when you get the grant will depend on the complexity of the application. Most are very quick. Most are straightforward.
Interesting. And how has that been impacted by the COVID-19 pandemic? I understand there's been some changes made at the law courts and the probate desk particularly.
Yeah, well, I don't want to get too legalese. There's something called a limitation period. And the way that affects the probate rules is you need to provide notice to everyone who's affected by the estate and the will. And you need to send them this P1 form, which is your notice of proposed application. That needs to be sent to all affected parties 21 days before the applicant can go ahead and submit their materials and get the ball rolling. And under the state of emergency, our minister suspended any limitation period, which effectively meant that anything that was served during that time, the days aren't counted. I just want to keep this as simple as possible because it's confusing, but essentially what that means is if you served your material on an interested party anytime between March 19th and May 29th, it's not considered served until June 22nd. There's this blackout period. So essentially COVID created a blackout period for filing a notice of dispute and responding. So we can't issue grants on anything that was filed within that suspension window. I know that's a little bit complicated, so we tend to field those questions on a case-by-case basis. It's maybe not for the layperson. But in terms of the other impacts of COVID, the registry is close to the public, but there's people are still here working every day, and we're getting through the applications. really there's been no decrease in wait times. The staff are doing great. Staff are working from home, and we're still issuing grants.
Excellent. And Laura, just to confirm then, that sort of pause on the limitation period, that ended May 29th, is that right?
Yes. So anything
then
served, yeah.
Going forward, you can rely on that 21-day notice period that's that you would normally be relying on.
Exactly. And it will really only affect, at first we thought it would be a really big deal, but actually it's only affected a small number of grants. So for the average person, it might not even be relevant. So if you have any questions, give us a call. Super.
Thank you. You mentioned, Laura, that you know the applications go in and some of them are rejected. And when we spoke, you gave me a wonderful list of tips. And so, would you please take us through these top 5? And I say top 5, but Stacey will also be talking about some of them because there is some overlap. But we'd love to hear ways that you can increase your chances of a successful application.
Well, I've got 2 things prepared to discuss. One is main reasons for rejection, and one is main reasons to succeed. So however you spin it, those are your tips. 21 days, just like we mentioned, that time needs to elapse before you can go ahead and submit your application, because that gives the registrar the ability to deem the application unopposed. That 21 days is there for an interested party to file a notice of dispute if they disagree with the person who's applying for administration. If they have any issues with that, if there's issues with the will, any number of reasons, the reasons Nicole set out, that's what that 21 days is for. So don't file your material before 21 days, we will reject it. Exhibits properly marked and signed, that's a very common thing. Affidavits tend to be almost always properly commissioned, but then exhibits are attached to the affidavit, which is, you know, evidence or some little schedule, and often that's overlooked and they're not signed and commissioned properly, so we can't accept that as evidence in that case, and we have to reject. Serve the public guardian and trustee. There are the rules set out quite clearly when you ought to serve the public guardian and trustee. Those situations are when there's a minor and the will did not establish a trust, or there's a disabled person. The rules will set out when it's required. And when you do serve the public guardian and trustee, the registry needs to be provided with their comment letter, which basically says what they would require in order to consent to the grant being issued. Sometimes they say you need to post an administration bond in the interest of the minor, or set up a trust, or seek some kind of court order. So we need to know before we can move forward. Consents for pre-WESA death. You know, I'd probably rather not talk about this now, because getting into pre-WESA is not that common anymore, but under the old act, you had to provide consents, which is no longer required. So if you have any questions about that, you might just want to give the registry a call.
Yeah, and I might just jump in there, Laura. So that would be applicable to pre-WESA death. So when was WESA brought in? Was it
2014?
2014. So anything
becoming
before
rare.
that?
Yeah. We're seeing less and less of that. So yeah, I would rather not confuse, you know, information overload.
Yeah, fair enough. And
yeah.
then I interrupted you. I'm sorry. You were about to make
that's okay.
Your last point.
Yeah, and then applicants nominated by a spouse. If you don't apply under section 130, you don't always need an order. There are several other sections of WESA where you can apply with the consent of the majority, where you don't require an order. So that's another tip.
Fabulous. Thank you so much, Laura. And I have just one last question for you. which is, you mentioned that the registry will field questions at the registry desk, questions by phone. What kind of questions can the registry answer?
We can answer questions about where to find forms, where we would recommend you get help. We get a lot of questions like that. People often ask us what date we're checking applications because they want to know where they fit in the queue. Of course, that's fine. Questions on the status of their application. Is it waiting to be picked up? Really basic questions. We can't answer anything that teeters on legal advice, and we get a lot of that. And I believe it's because most people don't understand, and understandably so, they don't understand the difference between legal advice and procedural advice. So anything to do with even the question, do I have to get probate, like Nicole addressed? You know, we don't know the specifics of the estate, and it's not for us to say. Or what type of representation grant should they be seeking, or what would be the best route in a complicated case. Sometimes there's a will that's invalid, and so is it better to treat the application as though there is no will, or should they get a court order and have all the issues fixed? Those are legal. That's a question for a lawyer. That's not a question for registry staff. They're not legally trained, and even if they were, the court is a neutral instrument, so it would never be appropriate to answer those questions. So that's really key. The other thing we can't answer is anything to do with distribution after the grant is issued. That our involvement is complete, and we don't really know anything about distribution actually, and that is part of a much broader piece of estate administration, which is not our job. So really procedural, really basic questions.
Yeah. And that's helpful, I think, for people to know phoning in that is the scope of the assistance that they will receive when they call in too. And one sort of follow-up and truly final question, do you see non-lawyers navigating this process on their own, or is this something that you see?
Lots of people do it on their own, and it's completely doable, especially if it's an uncontested, straightforward estate, either with a will or without a will. There's no downside to attempting to do it on your own, because if you make mistakes, the registrar will let you know, and they will issue you a rejection letter explaining the reasons, and then you have an opportunity to fix your application. And at any point, if you find it too much, if the registry starts telling you you need an order, or I don't know, if it gets really complicated, you can change course and say, well, now it's time to get a lawyer. There's also a lot of information available. There's some great probate kits commercially available. You can buy them in a bookstore, you can get them in a library. There's lots of information online. And even simply, as intimidating as it seems, even reading the Supreme Court rules to do with estates, Section 25, and the Wills, Estates, and Succession Act, it can really guide you. And people shouldn't feel intimidated by it. Give it a shot, and you might succeed, and the staff will help you.
Yeah. Thank you so much, Laura.
You're welcome.
It's really wonderful to hear from you, and we really appreciate you and the input that you're sharing with us.
No problem. Thanks for having me.
Thank you. And we're going to move into Stacey's questions, and I'm looking at the time, and I have a feeling we're not going to have a huge window for the Q&A, but I think we'll maybe extend a few minutes, going a bit past 1 o'clock, to allow for some of that Q&A if it's okay with our presenters. But I'm sort of foreshadowing a few steps ahead. So we'll cross that bridge in a few minutes. Stacey, you had a number of comments for strategies to approach and really tackle the forms that come in connection with probate. And the first comment that you had was in relation to the application for search of wills notice. And I'm wondering if you can share with us what your thoughts were on that.
So when you search for a wills notice in the Vital Statistics Registry, which is mandatory to do when you do an application for an estate grant. It's important to include any and all names or aliases of the deceased, so that if you do find later on that there might be another name that that person is known by, then you won't have to order a new one. And because sometimes they take 3 weeks or more just to obtain your results. So it prolongs the time it takes to receive it. The other thing that I wanted to note about the wills notice search is that usually what we do is wait until we get the wills notice search results back before we send out the P1 notice, just in case there is a later will found that we don't know about.
Excellent. And Stacey, where would you go to find all these names? Like if somebody were to present you with a file and you're trying to find all the different names and aliases, where would you go?
What we would do is we would look at like bank account statements. So sometimes, you know, they might have an initial instead of a full name for a middle name or something like that. So we would put that as an alias as well. The other place that's very important to check is the land title office to make sure that any name that's registered on title for any real property is caught in the wills notice search.
Excellent, thank you. Now, another form that seems to be somewhat problematic is this P2 submission for estate grant. So can you share with us some tips on how to complete that form in a way that will not result in rejections?
So the P2 submission for estate grant is essentially like, it serves the purpose of almost a requisition, where it identifies the person who is applying for the estate grant, and it also identifies the deceased and their information as well. The other thing that it does is that it lists out all of the documents that you will be supplying with the submission for the estate grant. So some of the things that are tips for the submission, use the word none instead of the acronym NA for not applicable. The registry, and Laura can comment on this if she wants to, the registry doesn't accept the term NA. So if there is a question in the submission that doesn't apply, you do need to write out the word none, or I do believe they also accept nil as well. And another one is that when there is a will, you should use the exact names in the will for the deceased, the executor, and the beneficiaries, so that everything is consistent. So that leaves no question to the courts as to who you're talking about. If there is a mistake in the name of anyone in the will, what you can do in your application is you could write out the name as it was reflected in the will, and then, or sorry, as the correct name, and then you can put beside that referred to in the will as so-and-so. And then again, in the schedule for the submission, if there is no living spouse, you can indicate that, that there is no surviving spouse, but you need to put as per section 2 of WISA to clarify that there is no surviving spouse. And other things that you can do for a submission for a estate grant, though it's not necessarily mandatory, but it helps to clean it up, is to remove all of the italics phrases that are instructional. And you can also remove the boxes that you don't tick off. so that the form is like, when it's in its blank state, it's a little bit unwieldy because it's very long. But if you remove all of the boxes that you're not ticking and all of the schedules that you're not using, then that will help in making it more clear to you.
Excellent. Thank you so much, Stacey. Another form that you had highlighted is the statement of assets and liabilities. And that form, I think, can be quite daunting, just the name alone. And you had some tips on how to approach that. So we'd love to hear them.
Yeah, this form is one of the harder ones to do. So it's important that the statement of assets and liabilities, you need to put everything as of the date of death. So if you had an account statement that was from September 30th and the person died on October 10th, you couldn't use the September 30th statement. You actually have to contact the bank and find out what the balance was as of October 10th, the date of death, including any accrued interest to that date. And what else? You used to be allowed to write "to be determined" on a statement of assets and liabilities. And under WISA, you're not allowed to do that anymore under the new rules. If you cannot find the balance as of the date of death, then what you're going to have to do instead is obtain from the court what's called an authorization to obtain estate information. And that form you will have to apply for in addition to in the application for the estate grant. You have to do the authorization before they will issue the estate grant. And once you have that authorization and you submit it to the banks or financial institutions, those institutions have to provide you with the information that you are seeking within 30 days of them receiving your authorization. And one final point about the P10 is that in the P2 submission for estate grant, you should always ask for a court certified copy of the P10 because it is important to have that for the executor or administrator, especially if there is real property involved, because that court certified copy of the P10 will need to be appended to the land title office transfer.
That's so helpful. Thank you, Stacey. It's always good to request those at the outset.
Yes.
So we have a few minutes left. I'm going to just move into trying to get to some of the Q&A. I see we've got a very large number. We've got 44 open questions. What I'll do is I'll just ask a couple at the top. And is everybody okay? There's just a couple extra minutes after 1 o'clock in terms of our presenters.
Mm-hmm.
So let's do that, and then we'll move into the conclusion. So I think this first question is, what do I need to consider if people invite me to be an executor? And I don't know, Nicole, do you want to answer that one, or?
Well, I think it's important to be aware of as I mentioned, the very serious responsibility this involves. And if it doesn't look completely straightforward, or if it's potentially contentious, you should get some good legal advice in advance before stepping in. Interestingly enough, I just saw a case the other day where a professional stepped in to be executor, and he ended up being liable for $100,000 of legal fees. I mean, that's a unusually bad example, and I don't think that happens every day, but it's important to recognize that it's a very serious responsibility and it's full of potential liability and risk. And it's also important to think that you know, of course, you just want to do the best job you can, and are you the right person? And it's a great honor to be asked. I understand that, and it's a way to honor your loved one by carrying out their wishes. But it's important to consider if it's reasonable for you to take it on.
Absolutely. Thank you, Nicole. Here's, I'll just turn to the next question. What do I do if I cannot get information from my sister, who is the executor of my parents' will? Nicole?
Well, so, I mean, there's lots of ways you can, there's lots of different ways you can compel disclosure. I think the first thing would be to write a nice letter, like, you know, before you do the legal process, obviously, to enter into mediation and things like that. Executors are bound by rules. Like, so one of the rules is after you receive a grant of probate, you have 2 years before you're required to pass accounts. Okay, so if 2 years goes by, you're required to pass formal estate accounts, and if you haven't met that duty, there's recourse under the legislation. But communication and mediation are always the best way before you do the legal process, because legal process is stressful, expensive.
Through some of the Q&A, and I see a number of them have been answered within the link, and we're really at the hour. So we're going to conclude the Q&A portion, realizing that we went a little. I'm sorry we're not spending more time on them, but we've covered a lot of the information, and I see there's some questions about the Probate Registry, and Laura talked about that. So that should be clarified, and we've got some information in the links. I'm just going to go back into my shared screen. I'd just like to put up one last slide, which has got some information on it. And so thank you so much to our presenters who joined us here today. It has been so helpful. And Nicole and Stacey, we've got a link here to the Heritage Trust Estate Administration Bootcamp, which I understand really lays out the steps in the process for anybody who is interested. And Nicole, I understand this book is available on Amazon, but you're also open to having individuals write into the info at bcheritagelawcom website, and that you would be able to provide a PDF copy to anybody who was interested.
Correct.
And I would also, thank you so much. Thank you, Nicole. And I would invite people tuning in to check out the blog as well. There's some really useful and interesting information posted there. So Nicole and Stacey, thank you so much for joining us. Laura, thank you so much for joining us. It has been such a pleasure. And you've also provided us with some resources which have found their way into the links along the webinar, and we'll also be posting those when we post on our webpage a link to this recording and the resources referred to it. So with that, we'd just like to say thank you. And any final words? We will keep the line open for those of you who'd like to copy and paste some of the information in the links. But before, we'd just like to maybe say goodbye to our guests. So thank you.
Okay, thank you.
Thank you. Thank you for having me.
Thank you so much for being here. It's been so great having you.